Okay, good afternoon, everybody, and welcome to the sixth session in the spring 2023 SunoikisisDC program. This semester is focused primarily on digital approaches to cultural heritage, and today's session, which will be presented by Saima Akhtar at Barnard College and Andrea Wallace at the University of Exeter, is on physical, digital, and intellectual property restitution. We'll have about an hour worth of sort of presentations and discussion from our two instructors, and then we'll have some time at the end for discussion. If you're watching live on YouTube, please feel free to use the live chat feature, which is either just to the right of your video or just below your video, to make comments at any point during the session, or ask questions, or join the discussion at the end. And we'll keep an eye open for those comments, and we'll engage with them when appropriate. The other thing I just wanted to mention is, if you're following this session on YouTube, you can also find some suggested readings and an exercise for you to try out, to build on some of what we're talking about at the SunoikisisDC session page. There's a link to which is in the comments underneath the YouTube video. So please go there and get any further information you need about that. So I think that's all I need to say. I'll hand over now to, I think Saima is starting us off.
Sure, I can start us off. Is that okay, Andrea? Okay. Hi, everybody. It's nice to be with you all. My name is Saima Akhtar. I'm the Associate Director of the Computational Science Center at Barnard College of Columbia University. I'm really excited to be joining this session, so thank you to the organizers for inviting me. I see my contribution here as really just presenting a case study that I had worked on during my postdoctoral work at Yale University in the computer science department there. My background is in architecture. I studied architecture. I worked as an architect. I did my PhD in architecture. And then I found myself as the architectural historian on a cultural heritage project that aimed to digitize heritage sites in the Middle East, but more specifically, it ended up being 6 heritage sites in Damascus, Syria, during an ongoing civil war. So it was quite a challenging project to take on. I had lived and studied Arabic in Damascus at some point in my life, and also Cairo. So I was familiar with some of the cultural practices and the language. So I think that was an important skill set to have when coming onto a project like this. But as I walk you through the project, I just want you to keep in mind the different team members' disciplinary background. So that was also the exciting but also challenging part in kind of closing the disciplinary gaps that exist between hard STEM subjects like computer science, and then art history and architecture, and preservation practices. So I'll just start by giving an overview. The project was called Project Anka, and it involved 3D scanning and looking at materials and building modeling, wireframing. The idea was to really create this web platform that would be the repository for a lot of our 3D scans, where scholars, researchers, students, and the public could come and learn more about these cultural heritage sites, and also creating context around it with Street View panoramas that were similar to what we know of as Google Street View, but building it from scratch. And design aspects, as well as a research team that was collecting a lot of materials to give context to where these sites were situated and the history of their of how they were built and what the use function was. This was the platform. This is kind of the final project, and what folks were able to do is locate and pinpoint the sites on an OpenStreetMap and click on them and explore the projects that way. But before we get there, some of the things that I thought was really important to bring to a project like this was a storytelling element. So it felt a little disconnected to me to just engage in a lot of data collection without really contextualizing the storytelling aspects of this, what in terms of what the how people use the buildings in the vernacular sense, what function they had socially and culturally, thinking about responsible data collection and ethical representation, especially with working with team members that were in the midst of an ongoing civil war, and that this kind of digital representation of artifacts was going to be very much set apart from the reality in which the sites were. And really thinking about this language of risk, which was on trend at the moment. There were tons of initiatives around documenting cultural heritage sites at risk, especially in the world of UNESCO and some of the funds that they were handing out then, and primarily really targeted toward the Middle East around these ideas of like conflict and war and terrorism. And then ultimately the idea of digital colonialism, which is just the mass collection of data, hoarding of data, so that there's, in the same manner that a lot of physical artifacts were looted and plundered in colonial times. And so this kind of like neo-colonial aspects of how this worked in the digital realm. So we started the project by really understanding what is at-risk cultural heritage, like where are these sites generally located, and was there kind of a repository that showed where these areas were concentrated. And so what we ended up doing was going online and looking at pre-existing projects that were engaging in cultural heritage digitization. And so we started by not wanting to repeat a lot of the work that had already been done. But also is very difficult because this was an entire kind of Western project where a lot of institutions were taking advantage of these crisis moments, primarily in the Middle East, and trying to document as much as they could, sometimes by just parachuting in. And so we really didn't want to do that. We didn't want this to be a project where we parachuted in and out and just got the data and ran with it. So we created these ethnographic field guides and really made an effort to try to approach this as we were team members with the folks who were on the ground doing the work. Many of them would travel to Beirut, and we would have these online training sessions around ethnographic data collection, how 3D scanners should be utilized, where they should be put around heritage sites, how the scanning should work, what kinds of documentation, and in what order should be done. And so these were some of the documentation standards around gathering field data looked like. And we also did a lot of research on our side. So while those training sessions were happening in parallel, we were also doing a lot of work in our library. So looking at building typologies, how we wanted to organize this data, and how to really narrow down the work. So instead of doing kind of mass collection of like hundreds of sites that were possibly at risk, we narrowed it down to 6 building types. And so that's why our scope was limited in terms of the number of sites that we were trying to document. So we looked at different building typologies and the way that they contributed to the architectural history of the way that the city of Damascus had developed over time. And that included residential structures, hammams or bathhouses, palatial structures, vernacular like homes and settlements. So those are the kinds of things that we were looking at on the research side. as well as acquiring permissions for using images from the mass of scholarship that was available on the history of Damascus and architecture and art history. So this was a project that took a lot of work on the side of just really meticulous documentation, reaching out to authors who were still alive and asking them, hey, if we put together this thing and throw images online, is it okay? Can we get permission? Like, we can compensate you. So constructing the literature database was really important in terms of providing this like scholarly social and architectural history behind the sites that we are documenting. I was based in a computer science department and as well as the Institute for Cultural Preservation. And so on the computer graphics side, I was working with a team of graduate students and a faculty member who is an expert in computer vision. And they were working on this project called Cherub, which is a platform that collected multimedia documentation so that you could gather it all in one place and be able to annotate it and then eventually streamline it into a video so that it's like on the research side, we could understand all of the modes of documentation we had about a single site and then start to try to really like put this together as a narrative. So you can see here that there is an initial scan of a 3D model, and we looked at the various materials and calligraphy and the different components of the building that had significance historically, and how could we situate that within the context of a website. And then there was another platform they called Cherish. And the idea behind this was to be able to extrude and extract a 3D model from 2D documentation. So since we were thinking of sites that may not have a 3D kind of component to it, how do we situate plans and different kind of axonometric models so that we can extrude and extract a 3D model out of it and still be able to kind of investigate the different spatial experience of the sites that we're looking at. And this is just a screenshot of my screen when I was going through all of the photographs that we had of buildings. So another part of this that I think is really important to think about is the actual logistics of how you get data from one place to another, especially when we're talking about a place as challenging as Damascus, and the amount of data that they were working with. So there was a delay in how to, in actually documenting the 3D point cloud data and, you know, being able to get that all on a hard drive and send that over to Connecticut where we were. And so while we're waiting on that, which took quite a bit of time, what was easier to kind of send over to us were photographs. So photographs of the buildings taken at every like couple feet, so that we're able to get a sense of the details of the building, but then also be able to quickly put together 3D renders from the photographs using some of the processing programs that we had while we waited on the 3D point cloud information. So this is a very rough model using just photographs. So this isn't the 3D point cloud data, and you can tell because it's kind of worn away in parts and there's little like areas missing. But what we were able to do is use MeshLab and Cherub to be able to create some semblance of a 3D model from the photographs and start annotating so that we could practice thinking about how are we going to highlight some of the features and the importance of how these buildings are used and why they're socially significant cultural heritage sites. So that's an overview of what went into it. The team that I worked with were fantastic in terms of creating this kind of panorama view of the building once we did get some of that point cloud data, and created this really street view experience of being able to walk through, and you can kind of click on certain aspects of the building and learn the history of it. And there's some videos that we put together, and you see where you are in the plan, and it shows you where you are in the plan. And so this was really meant to kind of create more of a historical understanding of what these buildings are like, in an immersive way. And then the other thing that we wanted to kind of highlight was the historical geography of the region and the shifting boundaries and political geography of the Middle East, and how it's boundary map making. All these modes of representation are essentially political projects with intent that serve the interest of the people putting it together. And I think that that's a really important thing to kind of highlight when you're doing something like this. So at the end of the day, we were able to put together a couple first author papers in computer science journals to really document some of the successes and challenges that were part of this project. And we're able to present that in different venues. One thing that I'm really proud of is that I was able to put together a workshop for folks working specifically on digital documentation of cultural heritage and think about the ethics of it, especially when there's such large power discrepancies between the places and the people we work with, and the institutions in which we sit. And so this was the kickoff lecture for the workshop by Trinidad Rico, who's this fantastic scholar of heritage sites at risk, where she gave an overview of historically what the language of risk looks like from UNESCO to kind of these everyday documentation initiatives that were really taking off in from the 2010s onward. And another project that I'm working with Andrea and another colleague, Christine Khoury, and folks at the Met, is the White Cube Black Box conversation that we initially had at the end of April 2021 that looked at how digital practices can extend aspects of colonialism, not just in these kinds of projects that document heritage sites loosely, but also in the context of universal museums that create these narratives around cultural heritage objects and sites. So yeah, that's just an overview of some of the issues that came up in a project like that. Very complicated, and took a lot of time to think through, not just as we were going through the project in practice, but also it's hard to think about the broader kind of more sticky issues when you're actually involved in a project like this. And since I've had a little bit of distance from it, it's really helped to actually be engaged in conversations like these to think about, okay, what are the implications of collecting data like this? Like, who does it benefit? Who is it for? And when we think about the rights to data and who has ownership over it and who can leverage where it is and how it's contextualized, that really has an impact on how we tell stories about places, but also how the remnants of that data then tell like stories about like it's really about like history making and how history is understood in terms of the kinds of data that are available to understand certain cultural heritage sites and regions. And so I'll just leave it there and hand it off to Andrea. And then unless Gabrielle, you'd like to pause for a minute to see if there's any questions.
No, I think we can. I think we can keep on. We can keep on moving. If anyone does have any questions, then we'll see them as they go by in live chat.
Okay, great.
Great. So should I go ahead and start, Gabby? Awesome. So I'm Andrea Wallace. I work closely with Saima and also Gabby on a lot of issues related to some of our interests, our overlapping interests. But my background's actually in law, and I really think about how some of the questions that Saima discussed um, kind of create various legal questions that we need to consider. Those can be related to property, intellectual property, also contract law. Those questions will inevitably change depending on where certain activities take place because law is jurisdictional, it's territorial. So it may change from one country to the next. And so when we're thinking, especially about some of the activities that Simon just discussed, who owns the property or the data, right, as property, who has intellectual property rights in it, those may change from one country to the next, depending on who's doing the digitizing. So I'm going to turn the focus a little bit to some of those questions, both with respect to immovable cultural heritage, which would be situated in a country and not move. So someone might travel there to digitize it, as well as movable cultural heritage. And so these are things that are quite often sitting in cultural institutions' collections. And so what we're thinking about there is where the institution is, some of these same questions of power and ownership that Saima raised, but really looking at what happens when the digitization takes place within that jurisdiction by the institution as the possessor. So I'll go ahead and start with my slides. Gabby, I don't know if you're going to throw those up. Great. So one of the the themes that we're seeing kind of come out of some of these questions relates to this wider conversation on decolonization and restitution. So really important and useful paper and thinking around this is the paper by Eve Tuck and Kei Wayne Yang that's called Decolonization is Not a Metaphor. And what they really argue is that decolonization has to result in the return of indigenous land and property and life to the group, which is an interesting perspective for us to adopt and start from as well when we think about law, because law is very much tied to land and it's very much tied to jurisdiction. So when we want to exclude specific laws from applying or think about different value systems as applying to the activities that take place within those physical spaces, this paper is really important for us thinking about what happens when we do not allow decolonization to become a metaphor and it actually results in the return of property, intellectual property, land, life, and all of these things that have been taken as a result of colonization. Now, when we think about digital materials, we then have, instead of just some of these analog questions and physical property, we need to think about digital property, data, metadata, and the types of things that might have been created as a result of the dispossession. So this is where we start to kind of link up with these ideas around how decolonization should inform restitution or restitution initiatives, and where digital property, intellectual property, and these sorts of things come into play. Because as we all know, there's a lot of conversation going on around restitution at the moment. And if you sit back and you kind of take a look, you'll see that what's missing from the conversation is this discussion of digital property and intellectual property rights. So for example, in many of the articles that you might read, you'll see examples of the objects that are being returned to the communities of origin, but you'll see them depicted by digital surrogates for which an institution will claim rights. And when we think about copyright, we also understand that there's an economic benefit to claiming copyright in a work because it allows you to commercialize that work. It allows you to charge others for access to it, to reuse it. And so there is an actual economic benefit that goes to the person who holds the digital property as well as the intellectual property. So this is a key dynamic that's not being addressed in a lot of the restitution initiatives at the moment, but it's also something that, of course, may sit adjacent to some of these restitution initiatives because they primarily focus on how to change national laws to enable cultural institutions to deaccession some of their collections and return them to communities of origin. One thing that's important to keep in mind is the way that intellectual property rights work, and especially copyright, is that copyright is an automatic right, okay? It arises in any original content that you or others create. So that can be text, visual works, sound recordings, database content, computer programs. But we think about it as arising automatically in anything that is sufficiently original. And in law, that threshold of originality in order to attract copyright protection is really low. Okay, so we're not thinking about original in like the plain meaning of the term or even in the art world. It's a very, very low threshold to meet, which means a lot of the materials that will have been produced by cultural institutions or which are produced by people who travel to different regions to digitize will attract copyright, or at least that's our base assumption. If it's not sufficiently original, then we would say that it's part of the public domain. But so long as something is protected by copyright, then that term of protection is going to last for the author's lifetime plus an additional 70 years after their death. So this is really long, especially when we think about digital materials and how they're more ephemeral than analog materials. And whoever holds the copyright or transfers that right to someone else, which is why we think about the right owner or the right holder, they enjoy all of the rights in the bundle, the right to commercialize, the right to exclude other people from using it, all of these sorts of things. So there's power in copyright ownership in and of itself. That rights holder then has that monopoly over the entire term of a copyright. And of course, they can leverage access for fees. And the public can access the work through certain exceptions and limitations, again, in national copyright law. So those exceptions and limitations will also be territorial. But we're seeing increased kind of harmonization across countries by international conventions that are telling us what is and isn't original in a way that gives us a little bit more certainty in that. But what's also important to know is that copyright is typically accompanied by what are called moral rights. And these may be the rights of the author to be attributed when the work is used, also the right of integrity. The work can't be used in a derogatory way that would have a negative impact on the author's reputation. So these are other things that someone can benefit from as a result of digitization. And in general, people who don't hold those rights, the general public, whether they're the public in the country of possession or in the community of origin, they have to assume that a work that they encounter is in copyright unless there's evidence otherwise. And there are other types of rights that might arise. We want to address these, but you can see how it does start to get a little complicated when we think about digitization as producing both property and potentially intellectual property. So this is where that, kind of core legal question comes in. Does copyright arise during digitization? And the key question then is whether that digital reproduction is sufficiently original and separate from the source work that's been reproduced to attract a new copyright. So this is effectively determined by the range of creative decisions that might be taken during the reproduction of the work. But again, this is something that will arise automatically. And so the person who's made the reproduction makes that decision. We have increased law and policy coming from the EU and the US that tells us it's really unlikely that when your intention is to faithfully reproduce a public domain work, like you're creating a copy, then you're not going to get a copyright in the digitization. But this is only a copyright question. And especially when we think about restitution and the types of materials that we're looking at, there can be bigger questions that we need to ask about whether we should digitize. If we do digitize, who has access, who makes decisions around that, and what the impact of an intellectual property claim is in the digital reproduction, as well as saying that that reproduction is in the public domain. So why does it matter? Well, because when you say that something is in the public domain, you are making a decision for a community of origin that you potentially have been able to benefit from the entire time that you've been in possession of the work. So for example, the Benin bronzes. We're seeing a lot of discussions around the restitution of the Benin bronzes, when they should go back, how thorough the different ownership is in different countries and all of these things that kind of control it. But we're also seeing kind of some discussions around, well, let's digitize everything. Let's publish it under open access so that everyone can use and enjoy it. Meanwhile, the institutions who have held these works historically have been able to benefit through their commercialization through the intellectual property rights. So the question is, well, why shouldn't the community of origin now that it goes back? So this, to kind of give you a very specific example, is something that has kind of arisen and materialized in some recent legislation in France. So France is one of the first institutions to change national law to create an exception to alienate public property. So these specific objects that technically are owned by the public and in a public institution, in order to send them back to the community of origin. And one of the institutions in France, which has an incredible amount of sub-Saharan African cultural heritage, is Musée du Quai Branly. And so when you go and you look at the digital collections that are in there, you're not just going to see examples of the works themselves, but you're going to see some of the associated materials, pictures of individuals, even exhibitions and installations, and things that relate to either the act from which dispossession occurred or even the object that the community of origin was dispossessed of. And so this really led to these calls to start returning, especially some of the Benin bronzes, and this report that was commissioned by France of Felwinsar and Benedict Savoy on the restitution of sub-Saharan African cultural heritage. And in that report, there was this paragraph about digitizing objects and making everything available online, creating a portal so that everyone would have open access to them. And some of the recommendations that we've seen that mirror open GLAM and open access movements that are about making cultural heritage more accessible, more reusable for the purposes of new knowledge generation, learning, and creativity. But one of the things that we want to think about here is what is the impact of making those decisions in place of the community of origin, especially when we go back to what I mentioned at the beginning, where an object is physically located, when it is digitized, all the copyright laws of that country will attach to that object. So in the case of France, that would be perpetual moral rights. It would be all sorts of things that then would follow the digital works back to the cultural institution, the community of origin, and even restrict their ability to use them depending on how those are exercised or defined. So this is, kind of what we're thinking when we think about what is the digital in restitution. It's not just the digital materials, it's the rights, it's the metadata, it's the collection of itself. It's all of these things that have become part of collections management processes and part of the infrastructure of cultural institutions. So building on that, a paper that a colleague and I have written in a form of recommendations on digital restitution and intellectual property, Mathilde Pavis, who I work closely with on this topic. We have kind of set out some definitions and examples that are really intended to help people expand their thinking about what can be part of a restitution claim. And so even though we say digital restitution, we do also mean analog data and metadata and collections materials, just anything that's really associated with the work prior to digitization, as well as those things that have been digitized. And intellectual property restitution as being a potential lens through which we approach this, because even curatorial notes, different papers and things like this could essentially be part of the restitution process if what we're thinking about is casting a wide net to collect things that have been made as a result of and subsequent to that original dispossession. One of the things we should also think about is how open access in and of itself is not neutral, okay? When we make a decision for someone, an individual, for their likeness, their identity to be reused, we may relate differently to the materials and to the person who's identified in the work differently from the community of origin. So how do we want to create more equitable restrictions or limitations on reuse when open access allows, for example, this image to go into a data set and be used for machine learning, AI training, and these sorts of questions? At the same time, we're not here to give digital bad name, because it can be really important to think about linking infrastructures, linked open data, and different ways that we can aggregate data, which is currently siloed at multiple institutions, to construct databases that facilitate more restitution claims to be made. So of course, to be able to make a claim, quite often you need access to the evidence that surrounds the object. That's going to be in a cultural institution's collection. If it's been digitized, if there's provenance data, some institutional data may be more in depth than others. And if we can bring these things together, thinking creatively about digital can facilitate more restitution claims. And so this is something that organizations who are kind of undertaking this work for the ministries in Australia, or excuse me, Austria and Germany and even the Netherlands, are trying to think creatively around how can we use digital to actually support more restitution claims. Lastly, when we start to see intellectual property and digital property through these problematized lenses, we then can think a little bit more differently about the application of intellectual property or a claim to copyright and what that does with respect to the materials themselves. So this is a very high resolution image of a woman who died in a cave. And she then was taken by people who came upon her and a group of, I think, 12 other people. So, you know, even having this woman in a collection can be incredibly violent when you stumble upon that on a collection's website. But what can be especially violent is when the image itself is then used for commercial purposes, or the copyright claim, even if it's intended to be put there to protect the image, it's not going to achieve that in the way that copyright is designed to do. So this is something that's important when we think about not just deciding to not claim copyright, but what happens when we do decide to claim copyright. Because if we make the conclusion that copyright in a given image is inappropriate, we should also then think, well, if there is no copyright in this image, then it's effectively in the public domain, which then exposes it to different forms of exploitation that we also should realize are inappropriate. And so if that's inappropriate, is access, digital access, even appropriate? Is digitization appropriate? So approaching it through this lens of intellectual property can help us peel back the layers, you know, that we may assume are not problematic at all, based on habits, based on cultural practices, based on collections management and how it's developed over the years, but in ways that digital really pushes us to reconsider. So to kind of build on that point, this paper came out in an online magazine that was about the decision to return carvings to Kenya. And going back to the image that I didn't show, that was an actual individual, it was a woman. This, of course, is what we would consider to be an object, but not potentially to the community with which it is associated. It could have a personhood. So this was a comment that was made by a curator at the museum, saying we should not be curating people's souls. But when we see the ancestor that's depicted in this image as having a soul, or, you know, the work itself as having a personhood, should we also be digitizing and commercializing them? So again, another way to approach this, because what ends up happening is what cultural institutions do matter. And what we all do matters, of course. So when we normalize and start to change public perceptions around something that don't fit with the way that someone may see their own ancestor, we then see it become a part of popular culture and potentially used in ways that are damaging, harmful, and even violent to the communities to which they belong. So digital and intellectual property restitution in practice, of course, is a whole nother presentation. And really people are exploring this in ways that is allowing them to think creatively around what the right ways are forward for digital restitution and intellectual property restitution. But one example, the University of Aberdeen returned a Benin bronze more recently, which they are able to do because as a university, they're not subject to the same sorts of local or national authorities that might in the UK prevent an institution from deaccessioning. But they also assigned intellectual property and returned a 3D scan that they had of the bronze. And then when we think about how to create more equitable access and not rely so much on intellectual property, there's some really interesting technologies out there. For example, the Makutu CMS open source program and collections management system, which allows communities to set individualized permission levels, sometimes based on the status of an individual within a community, if they're an elder versus a younger member of the community, even gender, or specific types of objects that only certain persons should have access to. So this is a really interesting way to start thinking about technology as being a solution rather than intellectual property in and of itself. Lastly, as a lawyer, anytime anyone publishes a new policy, I'm always rushing to review it and kind of see what it says. And the Smithsonian published a shared stewardship and ethical returns policy that's really worth checking out, that focuses on care and reparative processes involved in collections management. And the first thing that I did when I looked at this was review it to see if there's anything in relation to digital materials. But what's also interesting, again, as a lawyer who can see the benefit of vague language or phrasing things to be more broad so that they are inclusive and therefore adaptable either to different circumstances or more sustainable in the long term. There's also nothing in here that precludes digital materials from being considered as part of the shared stewardship and ethical returns policy. So I would encourage you to kind of go look at this and see, what it holds and how you might interpret that with respect to digital materials as a bit of an exercise. So if you want to learn more about this, and especially the different types of intellectual property rights or the different types of alternative licenses or contractual restrictions that you can think creatively about when you're trying to design solutions, Mathilde Pavis and I have written a string of different policy documents and consultation on how to start thinking about digital and intellectual property restitution in practice. So thanks, Gabby. That's me.
Thanks, Andrea, and thanks, Simon. That was really thorough and useful. It's great. Do we have any sort of discussion points to be getting on? We'll keep an eye on the live chat for if anybody on YouTube has anything to add. But anything either of you wanted to raise, ask each other?
I think I have a question. So I was thinking about the afterlife of digital objects. So in particular, I'm thinking about how sometimes, and this has actually happened, when digitization efforts of cultural heritage sites, especially in the Middle East, somehow find themselves in places like video games. What does that mean in terms of ownership over an artistic object that has been slightly repurposed and altered? Does that then refresh the copyright over the object? Like, I'm just curious about like how those the legality of that works in those cases.
So this is, I mean, this is a very fascinating and problematic sort of, I think, reuse, which we've seen, not just with some gaming and recreations of areas, in the Middle East and, Call of Duty and these sorts of projects, but also when we look at collections, videos, images, and materials that are published by institutions that are published openly. So not just, maybe public domain or even just available online. So I can't remember the specific details, but someone was telling me about an institution that published early moving images of World War II veterans and people as they were, being filmed. And those videos were then used to train and basically create VR versions of people for the game, like the extras. So that's a likeness of a person who is dead that's being recreated in a gaming space. And so there's going to be ethical questions. There may not be legal issues because technically what's being appropriated is an individual's likeness and it's only protected if that person is dead. So these are the sorts of decisions, though, that we need to be thinking about when we apply open licenses or we even publish things to the internet, because technically, in order to have copyright infringement, you need to make a copy of a work. So the material that, again, is being copied, it's not through an actual copying of the video, it's just through the machine watching the video, right? And the machine being trained on the content that's in the video. And so Matilda actually does a lot of work around this and around deep fakes and thinking about how, what the impacts of these things are going forward. But I'm sure you've also seen the different kind of animated photos. I can't remember the name of these apps, but you can put, an old timey photo in and it would recreate kind of the moving image of, I think I saw Frederick Douglass smiling or laughing or, something like this. And those things are becoming increasingly popular as well. So there will be new intellectual property in the application, the computer program, there may even be patents and other types of intellectual property in addition to copyright. But when they use openly accessible, so not even it can be rights protected or it can be public domain, but just accessible materials, it's not always infringing through an act of copying in the same way that we might imagine. And so I think it becomes even more difficult when it's essentially an entire like cultural feeling and historical event that's fabricated or 3D scanned or put into a game that has a narrative that goes along with it. So this goes back to what you originally raised, Saima. But there's different pieces of intellectual property that will be within that game that we have to consider that someone will have rights in. Yeah.
Where do you think, sorry, I have another question for you. In terms of where the discipline of law stands, like how fast do you think parts of copyright law, like how are they catching up, and are some places better than others? Because I would imagine that because privacy rules are a little bit better in the EU and the UK as opposed to the US. I wonder if that's the same in this area too.
Yeah, so it's really interesting to be able to see where some of these kind of steps forwards are being made and through kind of what areas or what measures. So I think GDPR is a really interesting example. Of course, it only applies to personally identifiable information of a living person. So can't capture and account for all of these other things. But there can also be, instead of regulation of law and intellectual property and recognition of rights, there can be regulation of the technology. So we can see improvement through how we regulate the technologies and what they can be applied to. And so when we think about AI, there's been many different policy papers that have come out recently for establishing regulatory boards that would look at an algorithm and put the burden on a company who's applying for a patent or something to protect the intellectual property, subjecting them to an oversight process where they have to show that their algorithm has taken into account X, Y, and Z and will not produce a specific set of harms. And so I think these are the ways forward, because we're never going to be able, especially as these, we're seeing really complex media come together in different ways. We cannot anticipate and create laws that will account for and be adaptable to the various directions that everything is going. So really it is going to come down to regulation through technology. And so long as we have people, everybody vote, that are on board and actually know things like what Facebook is, no shade to US Congress, but we do have some lawmakers who are ripe to pass the baton on to people who have very extensive backgrounds and expertise in what needs to be done in order for these things.
Okay, well, that's good to hear, because my other follow-up question was going to be, how important do you think it is for lawyers to have knowledge of the general landscape of how technology works? Because when we look at the way debates are being shaped around the power that Meta and Google and these big tech companies have over our social landscape, it's actually quite depressing to see how these debates play out and how these questions are asked. So if like the right questions aren't being asked, then it's really hard to keep powerful folks to account. So I'm interested in that, not just because of like what your opinion is, but also, as you know, in my work at the center, like our idea of a technologist is vast, right? Because we want to train a new generation of technologists that aren't just computer scientists. Like we're really encouraging people who are pre-law, pre-med, like biologists, architects, like people who are studying dance, to like have some form of digital literacy, or at least like make it kind of open enough, like a low enough barrier of entry into learning about these tools so that they have some knowledge of it going forward, because there's no way we can escape the way that technology is encroaching on all fields across all disciplines. So I'm just curious about what you think about that in the legal field.
No, I mean, I think I agree with every single word that you said. And I was also going to ask you about how law gets incorporated into the curriculum, like what the kind of the reverse question of that is, because I think it's really interesting to consider, for example, law students who are engaged with these technologies. They're on Minecraft, they're using Discord, they have that practice-based sense of what's happening when they then move into and study and learn law. But quite often, I think sometimes, and maybe this is an assumption of mine, the opposite isn't necessarily true when we look at some of the focus on STEM and the kind of siloing of not bringing in humanities or not bringing in law or thinking about some of these ethical questions in the same way. And so like what do you think is the way forward with that?
I think the burden has been on social scientists and humanists for way too long. And if you just think of the path-breaking scholarship that has come out from like a Ruha Benjamin or a Safiya Noble or all sorts, primarily women and women of color, honestly, who are doing this kind of work. They've been thinking about this stuff for a really long time. They've been raising the red flags about it. They've been seeing it in their work, their primarily qualitative work. And I think it's about time for folks in STEM to really take some of the burden on themselves to think about, okay, so if our tools are creating social discrepancies and injustice in the world, then how do we redesign our tools to make a better world, to make a world that we can see ourselves and the next generation living in? And honestly, because I'm working with students who are younger and engaging with online platforms in a way that I didn't when I was their age or growing up, I think that they're much more savvy about some of these issues. They know how to use platforms in a subversive way that we probably, weren't as savvy around. And so it's either them kind of really subverting how social media is generally used, or they're staying away from it. They're careful about how their data is used, and they want to learn how to get into like responsible tech fields. But again, I work in a liberal arts college, and so for this self-selected group of students, they're really primed to think about these things. And computer science is only about 3 years old at Barnard College, and students before that had to take their core curriculum over at Columbia University, and many of them would say that it's just like a male-dominated environment. We don't feel like we can really talk, or there's space for us to talk about these things. And so we're in a really unique position where we can then, I think that this is the future of STEM fields, is really we're in the perfect position as a liberal arts college to start integrating some of these ways of thinking into the way that STEM fields are taught. For me personally, that's kind of where the future lies, whether it's happening. I know that some institutions are attempting to integrate ethical curriculum into the core computer science courses, but I think it's like few and far between. And maybe as these conversations grow and we have more attention on them, then we'll see curriculum and pedagogy changing in that way. But I personally feel like the burden has been on humanities and social science scholars for too long to highlight some of these issues.
I think to really get at questions of creativity when we're talking about AI is going to require much more sophisticated computer science understanding of what AI actually does. Because we often hear AI talked about as if it were analogous to human creativity. You know, the machine looks at lots of examples and then creates something inspired by that in the way that, you know, a filmmaker will have watched 1,000 films before they make their film, and you know they get lots of ideas from them and some new ideas and this. But that's not what computers are doing at all. It's much more like a collage artist. They can only copy. And they may be copying tiny, tiny chunks that are very, very hard for us to recognize that what it is as a copy. But it's still all copying. It's copying bits. And that has to be something that's much more detectable. And that requires computer scientists to be much more critical of what AI is, not just to throw it out there and throw data at it and see what comes out. You know, you have to analyze what comes out and see how it came from, where stuff are, which is, again, it's such a big task. You're gonna need AI to analyze the AI, but it's not creativity in the sense we normally mean it. We really have to be careful how we define that.
Yeah, I think you're getting at a really interesting point. I'm seeing this a lot in conversations around OpenAI and ChatGPT. And the reason why I think it's being received a little bit more positively is because they have put restrictions around certain results that are returned. So, for example, at the beginning, if you were to ask for a feminist take on some subject, let's say the use of AI in the cultural heritage field, I think that recently I've tried this request, and it's given me back a pretty standardized answer around some of these more hot topic issues. But previously, I think the answer was, I'm just a chat GPT machine, and I don't give commentary on certain race-based or gender-based questions. And so I think the reason why I'm seeing it used a lot in pedagogy these days, actually, and it should be interesting to see how ChatGPT is going to be incorporated in certain ways. And we see disasters, like I think it was Vanderbilt University that just issued an apology for using ChatGPT to draft an email about the shootings in Michigan State University that happened a week or so ago. And it's because the watermark of the ChatGPT was still at the edge of the email. And so we're seeing where it's acceptable to use something like this and start to experiment with something like that, and where we're seeing a pushback, like that's not appropriate to use a machine when you're trying to talk about like social issues that are very difficult to grapple with, and when you're offering condolences and when you're trying to, like, so yeah, and I agree with you that what the machine learning is doing is really just it's feeding on what is already out there, right? And trying to do analysis and spit out answers to, it's like a search engine, right? So Safiya Noble writes about this, is that the reason why Google search was so problematic in the early aughts is because there were no controls around what biases were built into search terms. And so she highlighted that, and the company eventually was able to build in mechanisms to respond to that, although not perfect, still not perfect. And I think we're seeing that around these tools as well. And so it's important for all of us to remember that these algorithms are only as smart and nuanced as the people who are making them. And we have yet to see them make novel and creative connections. So that's what distinguishes, AI from us. Like, we're able to engage in creativity and novel connections in a way that these machines have yet to do. And so I think you're right about that. But I agree with Andrea's that we can't anticipate where these technologies are going to go, where they're going to take us, what the relationship between AI and cultural heritage is going to be, for example. So, like, how do you create regulations around something that has yet to come? And so that's why I think it's really important to anticipate, or try to anticipate, some of these questions. And I don't know if it's a regulation around the design of tools or just moral, ethical kind of frameworks that we can all agree on in terms of what's best for us going forward.
Can I ask, sorry, and Andrea, if you're about to jump in.
No, go ahead.
Okay. Can I ask a question going back to some of the questions about more sort of traditional restitution of heritage, and you were talking, Andrea, about the restitution not only of the object but of the imagery, the digitization, the metadata and paradata and other things around it that belong in the museum. And I wonder if you'd either of you would say that there might sometimes be cases where even if a museum, so some of these pillaged or stolen or colonized objects will have been in the colonizing museum for 200 years or more, right? And so a whole load of curatorial history will have come in there, which is all valuable history in terms of understanding what's happened to the object and how it might have been restored and where it came from and all that sort of thing. And then all sorts of metadata that will have come around the object and so forth. Might there sometimes be an argument for the institution, when they've repatriated the object and presumably given a copy of all data and metadata associated with it to the new institutions, that there may be an obligation on them to then delete their own copy, to not keep a copy at all.
Yeah.
Because keeping it is not having fully returned what was stolen.
Yeah. So I think there's a lot of layers to all of those things. And it all comes back to, I think, for Matilda and me, which is, part of what we've written and we've argued, and, we're continuing to kind of to think about, is the moment of dispossession. If someone's been dispossessed, then everything that follows, regardless of how the institution then acquires, the work, should be subject to restitution. And I think in reality, it will play out differently, but that's an important power dynamic that helps situate all the conversations that follow, and it puts the community of origin in the position of directing those conversations. And so, the initial audit of what could be in the institution's collection should include all of those things, even things that, from a copyright perspective would be owned by the institution, the curator, a paper published in, a journal, that sort of thing. Because what we're really getting at here is the heart of the source of the harm. And, if the restitution audit results in this amount of materials being selected to go back, a small subsection of that is allowed to, stay at the institution. And then we even think about the agreements around reuse for the institution. Do we transfer the intellectual property rights and what remains at the institution, or the institution is permitted to, to keep copies of to the community of origin, and reverse those power dynamics around permissions, around commercialization? Like, this is, for some reason, too radical a position for a lot of people, but I think it's the exact same mindsets and power structures that make people think that that's radical, as it is for us to think there's nothing radical about this. It already exists. The only thing that's happening is someone else is in the seat instead of you. And so that worry and that fear of, what if we lose access? What if we can't study the work? Guess who's been sitting with that this whole time, right? So I think this is part of, like, the positioning that really has to inform what restitution is going forward. And there are a whole other set of concerns related to public law and even constitutional amendments or new legislation that's required around the physical material objects, however we want to call those. It starts to get really difficult to even be like, what do we call that stuff? Because digital is material and physical too. Do you know what I mean? So when we think about, the thing itself that was taken, I think that is subject to a completely different set of laws than everything else that's created around it over the course of possession. I wanted to ask Saima a question, though, because, and it's sort of related to this in terms of, I think, terminology and positioning, and the ways that we uncritically accept certain things. So that feels really abstract, and I'll just get really specific. So law, and Saima used this on his slide, looks at risk heritage, right? And this is a focus of UNESCO and cultural preservation and these sorts of things. But there can be even colonial and imperial histories related to what is perceived to be at risk and what is perceived to be safe. And I wonder if Saima could maybe talk a little bit more about that.
Can you be a little bit more? So do you mean from the perspective of, from a non-legal perspective? Or in general?
Well, so what's interesting is, in terms of, like, my discipline and how I've encountered it, it's been through cultural preservation, UNESCO, and laws that are enacted to protect cultural patrimony within a given country, right?
Okay.
And so then when you were talking about at-risk heritage, there's another layer to that, in terms of, this is why we digitize, this is why we preserve, and thinking about, like, obviously maybe we're taking specific steps to preserve heritage, but then when it's perceived to be at risk, it's often related to destabilization, areas that have been destabilized, right? And we don't necessarily think of things being at risk when they don't have those kind of, like, political contexts.
Right. Yeah. I'm sorry, I made you answer your own question.
Well,
tell
me more about your experience.
Just expand on your answer. Yeah, I mean, the whole frustration is that when, like, we are in the midst of climate change, right? So what do we think about as risk when we think about coastal regions, when we think about cities that are going to be half underwater at a certain point, when we have indigenous sites that have been overlooked for decades and generations, right? So this is the frustration around a very specific definition of what it means to be at risk. And I think the argument that Trinidad Rico really engages in powerfully is that it's an entire cottage industry that has been constructed by predominantly Western institutions around which areas they really want folks to focus on. So like, obviously, you're going to be focusing on regions that you can get grants for, that you can get powerful folks to support you on, like a UNESCO or a Google. If they're going to hop onto your project, you're going to gain legitimacy around it. You're going to have more funding. You're going to be able to hire more people. You're going to have more technologically savvy equipment. You're going to be able to engage in trainings where you can distribute that equipment and train folks who are really looking for other activities to engage in when they're in the middle of a very difficult or living in a situation where they're looking for a means of living, or they're looking to kind of continue their life in a regular way. And so it was hard to engage in those trainings, because I would always think about, maybe buildings are the last things on these people's minds. Maybe they're not as interested in what could happen to these buildings, but what could happen to them. Where are they going to go in the midst of uncertainty and conflict? And why are more resources not being dedicated to those efforts? And at the same time, I understand the worth of cultural heritage. I think that there needs to be a balance and a more nuanced conversation, which I think, is happening since that time. That was 2016 or 17 that this project started. And I think we've come a ways in terms of getting more folks, more underrepresented voices in these conversations that are not from institutions where we're all from. Like, if we look at all of our titles, we're sitting in the US and the UK for the most part talking about these topics. And I think that, especially over the pandemic, Andrea, you and I were engaging in a lot of conversations with people who had been trying to talk about things like Benin bronzes and areas in South Asia and Africa, where looting and the restitution of cultural heritage has been an ongoing issue for a really long time. And so I think that was a moment when we're seeing those conversations really starting to happen. And so, yeah, I think that it's really hard when there is a political project and there's a lot of support, ideological and financial support behind it. It's difficult to kind of be able to point to other areas that are underrepresented and underfunded. And so I think it's really the people. I'm trying my best now to talk about this from whenever I can. And so I think that it's just important to highlight these issues and talk about it and bring attention to it, and talk about projects like you do. You talk about projects where folks are taking novel ways and unconventional ways to highlight other ways of thinking about intangible cultural heritage. So I think that we've come to a point where we've problematized that concept of being at risk, but I don't know if the future of these preservation efforts is really taking that into account, but we'll see. Are there any questions in the chat? Or
no, there haven't been any yet. No.
Okay. Oh no, did Andrea?
We lost Andrea for a moment. Hopefully she'll reappear.
Okay.
I was about to ask her to talk about the exercise. I assume that was her exercise.
Oh yes, it was her exercise.
Here we go. She's back. Great.
Okay.
Great.
Sorry.
Good. Cool. No worries. I was just going to ask, actually, since we're close to running out of time, if Andrea, you wanted to say a little bit about the exercise, talk through that. The one thing I'd say in terms of putting that in context is that in the exercise you don't mention Creative Commons per se, which is an essential sort of bit of background knowledge. So anyone who's been following this whole series, I will have briefly introduced Creative Commons about 4 weeks ago in session 2 on Wikipedia, but But for anyone who's not who's just watching this as a one-off video, as it were, that's one of many places you can go to find out more about Creative Commons, of course. But yeah. So Andrew, do you want to say a little bit about the exercise you're suggesting for this week?
Yeah. And my apologies for that, because I had a couple of slides at the very end that I forgot to insert that were about following from Makutu, the different types of even indigenous labeling and tools that are out there that can only be applied, obviously, to the heritage by the groups and the people who own them and associate with them. But there are increased examples of licenses that sit on top of like the copyright system and actually exclude people based on really interesting kinds of concepts and terms. So Gabby mentioned the Creative Commons suite of licenses. So that is a suite of licenses that is intended to waive different rights in the bundle of copyright from the outset. So a creator who wants to allow people to reuse their work commercially and has, no real concerns other than wanting to be attributed as the creator of the work might apply CC BY, which is the Creative Commons BY or attribution license. And that just requires someone to cite them and include their name when they reuse that person's work. They can use it for commercial purposes, they can do anything. So those sets of licenses are intended to waive different rights in the bundle, and they do sit on top of a valid copyright. The licenses that we've highlighted in the exercise have a bit of a different take on that. And so we've termed them alternative licenses because what they do is they essentially exclude certain groups from using the copyright protected materials, and they're really interesting. So some of them exclude any reuse of material. So they technically would publish the materials for anyone to reuse, except for purposes that are to incorporate things into technologies that are used for surveillance or machine learning and facial recognition, and these sorts of things that become tools that police public spaces and harm people. So there's some really interesting ways that people are starting to design licenses so that everyone can use it except for people who come to the table with those sorts of intentions. And I think that's a really interesting way maybe to start with, or to go back to Saima's initial point, when we're thinking about how we publish things and make them available, if we want to preclude specific uses of things where we can foresee or perceive a harm that might come from them being made available, while also still making software available for educational reasons, or someone who wants to use something commercially but has no desire to incorporate it into evil technology. So this is just an example, but we've included links to a bunch of those, and they've got some really creative terms. Some of them have names that go right along with them. So it's a way for you to think about, what is it that I'm making, and what could I potentially see it being used for? How would I want to exclude or restrict access or reuse of those materials in a specific way? And I think the sky is really the limit. So it could be a general license that would just apply to everything that you make individually as a person, that you would apply to your creations, or it could be something that you're thinking in relation to the specific thing that you've created and what you don't want it to be used for. So that's how we've set out the exercise at the bottom of the page.
And I guess when you're thinking about that exercise, you could think not only about the license and the license terms, but about what you're applying the license to. And if you've been following this program and you've been in previous weeks, for example, producing 3D models or producing GIS output, or producing Epidoc object descriptions of text-bearing objects, you could think about how the publication of those would be impacted by using some of these other alternative licenses, or your own license that you're envisaging. It's worth stressing that all of these licenses, just like Creative Commons, they all work within the scope of copyright, right? They're all a little bit more liberal than copyright. The only things they're restricting are, we're waiving copyright except for, in these cases. Then none of them are less restrictive. Sorry, none of them are more restrictive than default copyright.
Right.
Not saying you can't read this if you're a cop, right? Great. Cool, fantastic. I think that was really, really useful. Does anyone have any last points to make?
I actually had a lot of fun.
Me too. Always.
I'm actually surprised we're able to talk for about an hour and a half, but I felt like it was really engaging and interesting. I hope folks out there find it interesting too. But
I hope so too. I hope we'll hear from some perhaps in the comments. But, great. Well, thank you both very much. And to people watching, please join us next week when the session will be on 3D modeling and for the rest of the semester. Cool.
Thank you.
Thank
Thanks
you.
a lot. Bye-bye.
Bye.